everyone, welcome to Crystal Diaries. This is another video of a series of videos relating to law of contracts in India. And in this video, we are going to read about agreement in restraint of trade. So before we begin this session, please bring your Barrett so that we can read the Barrett simultaneously, and bring a notebook along with a pen so that we can write all the important points we discuss here. So let us begin. Section 27 of the Indian Contract Act says about agreement in restraint of trade void. So the general rule is every agreement by which one is restrained from exercising a lawful profession, trade or business of any kind is to that extent void, which implies that any agreement, if it is made in order to restrain someone from continuing a trade or any kind of business that is lawful in nature, it is void to that extent. And this principle is same both in England as well as in India. Also, one important point to be noted is that no matter whether the restraint is partial or whole, it is void. So if someone says that there is a partial restraint and we should agree on that, or we should make an agreement to impose a partial restraint, that is void. So it doesn't matter whether it is partial or whole. But why is it void? If both the parties are agreeing to the same thing in the same sense, then why has the law declared such an agreement to be void? It is because it violates Article 19(1)(g) of the Constitution. As you know, that freedom to trade and business is also one of our fundamental rights, and reasonable restrictions can be imposed. And we are going to read about this in our exceptions. But let us first understand that why it is not, why it has been made void. So first is it violates Article 19(1)(g). Second, it is against public policy. Third, it prevents competition. And fourth, it promotes monopoly. So for these all reasons, such an agreement, whatever restrains the trade, has been declared to be void. Now let us read two case laws which are very important in order to understand this provision. The first one is Madhuv Chandar versus Rajkumar Das. In this case, A and B carried on the same kind of business in the same locality in Calcutta, and B agreed to pay some amount to A if A closed the business in that locality. A closed his business and then brought an action against B to recover the promised amount. And you know what the court held? The court held that even though the restriction was merely a partial one, restraining A from carrying on a particular business only in a certain locality, it was still void, being in restraint of trade, and therefore A was not entitled to recover the amount. So now let us come to the other case, that is Nordenfelt versus Maxim Nordenfelt Guns and Ammunition Co. Limited. In this case, the appellant Nordenfelt was the manufacturer of guns and ammunition. He sold his business to the respondent company for some consideration, and he agreed that for 25 years he would not engage either directly or indirectly, first, in the trade or business of manufacture of guns, gun mounting or carriage, gunpowder, explosives or ammunition, or secondly, in any business competing or liable to compete in any way with that for the time being carried on by the company. And in this case, the court held that the first part of the agreement provided a reasonable protection to the interest of the buyer of the business for such a large sum, and it was valid. Whereas the second part, requiring him not to compete in any business, was unreasonable and therefore void. Now that we know the general rule, now let us understand what are its exceptions. The exceptions are to be read under three heads. The first is statutory exception. The second is the exceptions that are provided in the Partnership Act 1932. And the third being judicial interpretation. The judicial interpretation has also recognized some of the restrictions which are valid in the eyes of law. So let us start with the statutory exception. So the Contract Act itself provides the first exception, that is sale of goodwill. So whenever there is a sale of business by a person, along with its goodwill, the seller of the business may make an agreement with the buyer not to carry on the business in competition with the buyer. So what happens here, that an agreement by a person who sells the goodwill of his business is not to carry on a similar business within the specified local limits so long as the buyer carries on a similar business. So this agreement is valid. But the restriction should be reasonable. Why? Because when a person purchases the goodwill of the business, he pays for the right to carry on a certain type of business in exchange for an express or an implied promise by the seller not to carry on that type of business. So it will be contrary to the spirit of the contract of sale of goodwill if the seller of the goodwill who has received money for the same starts the business in competition with the buyer again. So if the object of the agreement is to protect the right of the buyer of the goodwill, the restraint is valid. But on the other hand, the restraint merely aims at avoiding competition, then it would not be valid. So if the agreement in essence is a covenant against competition rather than the sale of goodwill, it will be void. So for the applicability of this exception, these points, whatever has been given in the bullet marks, has to be taken into purview. The first is they must relate to same business. Secondly, the restriction is to apply within specified local limits. Third, restriction for a reasonable time. And fourth, restriction depends upon the nature of business. Now, let us look at the second set of exceptions that has been provided in the Partnership Act. So, the Partnership Act has also provided some of the exceptions in section 11, 36, 54 and 55. So, section 11(2) says that none of the partners would carry on any business till the continuity of the partnership. And the second one is section 36 subsection 2, which says that the remaining partners are to prevent the outgoing partner from opening any business similar to theirs in the same locality subject to certain restriction. What do you mean by outgoing partners? So when people are being partner with each other and one of the partners decides that he doesn't want to continue and he moves out of the partnership. So in that case, the still existing partners can impose reasonable restriction on the outgoing partner that he should not conduct such similar kind of business in the specified locality, but such restriction should be reasonable. Now section 54 prevents that all the partners from engaging in any business of similar kind after the dissolution of the firm or business. And fifth one, section 55 clause 3, that restraint of trade after the sale of goodwill. So after someone sells the goodwill, the same restriction will apply, whatever we have read in the statutory exception. Now let us look at the third set of exceptions, that is judicial interpretation. So first is trade combination. So under judicial interpretation, the first one is trade combination. So what is a trade combination? Sometimes the traders or manufacturers combine together to eliminate competition as between themselves, and they make agreements fixing minimum price, regulating the supply of goods and putting profits in common pool and dividing the same amongst themselves. So in such case, the agreement is neither void on the ground of being opposed to public policy, nor are they deemed to be in restraint of trade. But there is an exception. This agreement should not tend to create monopoly, otherwise it will be void again. Now the next one is restraint by a contract of service. So a contract of service is also an exception. So if there is an agreement of service under which an employee agrees that he will serve a particular employer for a certain duration and that he will not serve anybody else during that period, it is valid. Now for that we need to know a particular case law, that is Charlesworth versus MacDonald. In this case, the defendant agreed to serve as an assistant to the plaintiff, who was a physician and a surgeon, for a period of 3 years, and not to practice himself during that period. After 1 year, he left the plaintiff's service and started his own practice. It was held that the plaintiff was entitled to restrain the defendant from practicing during the period of agreement in that particular area. Now let us come to the third one. But before that, please note a very important point, that according to the Specific Relief Act 1963, a contract to serve a particular person is not capable of specifically enforce. Yet the negative covenant saying that the employee will not serve anybody else is valid and enforceable. Now the last exception is solace or exclusively dealing agreement. So it is known by both the names, either solace agreement or exclusively dealing agreement. So what is that firstly? So the trading agreement whereby one party agrees to deal only with the other party and none else is the solace dealing agreement or exclusively dealing agreement. For example, an agreement to sell all the salt procured during a certain period to particular buyer only. But this also has exception. First, when the buyer does not agree to purchase the whole quantity, he cannot restrain the seller from selling his surplus to others. And secondly, when the object of the agreement is to corner goods or monopolize trade. So these are the exceptions to the general rule. I hope you understood the general rule, the exceptions along with the case laws. So till we bring the next video, keep revising and take care. Bye-bye.